Good afternoon. Again, I'm Hal Humphreys. I'm the Director of Education here at PI Education. Today we have joining us Lindsay Lanehart Craig. Lindsay Craig lives in and works in Lubbock, Texas. She comes from a long line of legal heavyweights. Her dad is a high-profile criminal defense attorney. Her mother retired as a county court at law judge a few years back. I met Lindsay several years ago while working on a mock trial. Lindsay and her mother put together a detailed jury questionnaire, and they analyzed feedback and data from 4 separate jury panels. Her work on that mock trial likely helped the attorneys get a hung jury in the real trial. I know Lindsay to be a consummate professional and a hard worker. Since our work together on that mock trial back in the day, she has assisted countless attorneys in preparing for trial. She helps with jury selection, AV presentations, and mitigation. Lindsay has a deep knowledge of the criminal defense proceedings. She has a strong interest in helping citizens accused of crimes. So in 2015, Lindsay hung out her own shingle offering mitigation and litigation support services as Craig Trial Consultants. Lindsay is a mitigation specialist. She's one of the smartest people with whom I've had the pleasure to work over the past several years. So we're thrilled that she found the time after several begging sessions from me to join us here on the PI Education monthly webinar for October. Today's topic, mitigation investigations. Lindsay, if you don't mind, tell us a little bit about yourself.
Well, sure. Hi, I'm from Lubbock. I'm born and raised here. I got my undergraduate degree at TCU in Fort Worth, radio, television, and film, and then moved back to Lubbock, and I ended up finally going to graduate school after about 12 years, and I got my counseling degree at Texas Tech University. Graduated in May of 2015 with that. And then within that time, I had a child. He's now 5. Married. I have a husband named Rob. And we live in Lubbock. And I started my own business as a mitigation specialist and trial consultant September of 2015, and I'm loving every minute of it.
And I can say, and this is full disclosure, like I said earlier, I've known Lindsay for quite some time and have developed a strong friendship with her over the years. Her husband, Rob, is someone that I consider a close friend, and he is one of the best cooks you'll ever meet. Anytime I'm working out in Lubbock, I get the chance to eat at their house and hang out with their son and Rob, and the man's just a phenomenal cook. So shout out for you to Rob for that.
I agree.
Real quick, I want to go over this for our listeners. We've got several people in the room now. This is not legal advice. We are not attorneys. I'm an investigator. Lindsay is a mitigation specialist. Anything we say here is just our opinion. It's not legal advice. If you have questions about legal issues, talk to your lawyer. I have a notion there are probably some lawyers in the room today. If you hear us say something that is wrong, please feel free to reach out to us and let us know. There's a chat function on the right-hand side of your screen there. You can share things with us there. So again, this is not legal advice. This is just our opinions. Lindsay, we're talking today about mitigation. And I know for a lot of folks out there, they just don't know what that is. What is mitigation?
Okay, well, first of all, it's not meditation. And second of all, it's not mediation. It's mitigation. And what mitigation means is to make lesser or to lessen. And typically when it's involved in a criminal case, it means to lessen someone's punishment. So that's, in a nutshell, what I try to do is help someone get a lesser or maybe a just punishment by figuring out who they are as a person instead of just as an accused criminal.
And when you say figure out who they are as a person, and we're going to go deep into this topic. We've got a full hour to talk about mitigation. When you say find out who they are as a person, talk to me about how far you go back.
To birth. Yeah, I mean, I start with, from when they were born, if there was any issues with their birth, issues with them, issues with their mom, if they know, if their mom maybe used drugs or drank alcohol or, anything, if a cord was wrapped around their neck when they were born, they had any issues. And then I start there and I work my way all the way up until the present time that we're talking.
When you're called in to work as a mitigation specialist, let's kind of walk through, and one of the things we try to do in these webinars is provide tips and tricks and best practices. Talk to us a little bit about the process. If you have an attorney that calls you to work on a case as a mitigation specialist, what's the first thing you do?
The first thing I do is I meet with that attorney about the case. I find out, who their client is, what they're charged with. I'll read whatever discovery they want to give me, any of the police reports, videos, anything that that the attorney would like to share with me. Give me some sort of brief rundown so that I kind of know a little bit about what I'm getting myself involved in.
Right. And the interesting thing, and you and I have had this discussion on a number of occasions about becoming a private investigator. I know you have no interest in doing that, but the work sounds very similar. And I think, and you and I have had this conversation a number of times, the work is pretty similar. As a private investigator, the starting process for me for criminal defense work is very similar. I'll sit with the attorney. I'll get a brief rundown from them about what the case is about. Any discovery they can share with me, I like for them to share with me. So that sounds really similar. Once you get that information from the attorney and you've gone through, what the situation is for your client, what the attorney is looking for from you, then what is the next step that you start?
Okay, let me point out one thing real quick before I get into that question. I'm stubborn. And if you tell me I need to become an investigator, I'm going to say no. So you should tell me, don't be an investigator, you can't hack it. And then maybe I'll think about it.
A little bit of reverse psychology might work on you.
Yeah, and I know that about myself. But anyway, so the next step is I go and meet with the client. After I've read the discovery, I'll go and meet with the client. And I kind of give them a spiel about who I am, what I do, what mitigation is, that I'm here to help them. I make it known that it's important for them to be honest with me. I'm not there to hurt them in any way. There's nothing that they can tell me that can hurt them. And the only person that's going to know what we talk about is the attorney, and the only information the attorney is going to use is to help them.
Right. And as a mitigation specialist, I know when I'm working on a criminal defense case as an investigator, the work that I do is considered work product for the attorney. Is that the same thing with the mitigation specialist?
That's correct.
Okay. So you've got some serious protections in the information that you share with the attorney that's not going to be discoverable by the opposite side.
Absolutely.
Okay. Do you ever get any pushback from your clients that don't want to talk to you about their history?
Yeah, sure. Sometimes it's hard for me to tell. I'm still pretty new at this. I mean, I've only been doing this as full time for a little over 2 years. So sometimes it's hard for me to tell whether they're being completely honest with me. And I think, the longer that I do this, the more I'll figure out who's being truthful and who's not. But I think that's the hardest thing. Some people, some of the guys mainly will embellish a little bit. And I'm coming to figure out how to detect that now. But yeah, I mean, some people will just tell me everything. I mean, there was one client that I met with probably 3 or 4 times for 3 or 4 hours at a time to get his whole story, because he just wanted to keep talking to me, and that's okay. I want to know as much as I can know. But then, yeah, there's some that are just kind of a little more standoffish, and it takes a little more time to earn their trust and get to know them.
And I think that's probably one of the key differences between fact investigation and mitigation investigation is you're spending more time with the person. You're talking about deep, long personal history, and you've got more time to spend with them to develop that trust. But you have to develop trust. And as investigators, be we mitigation investigators or fact investigators, building trust is one of the most difficult things to do sometimes. Do you, and I want to go back to, you mentioned the idea of being able to tell when someone is not being truthful with you. That is one of the hardest things that we have to do as investigators. And I've told this story a number of times, and I'm going to tell it real quick. I interviewed a lady in Texas one time. I was working on a death penalty case. It was an appeals case. And I had just like the month before taken a course on deception detection. And I was cocksure that I knew how to tell when someone was lying to me. So I interviewed this lady, and I got on the phone with the attorneys after the interview, and I said, I think she's being forthright with me based on my training and, deception detection, blah, blah, blah. Turns out she cited a book she was reading as a reference for how she knew this thing happened, the event that she was talking about. She cited this book. She was very sure about the book. She knew the author's name and the title of the book. That night, while I was in the hotel, I kind of did a little research and figured out that the book was published 4 years after this alleged event took place. And I had to call the attorneys and tell them, oh my gosh, I did not, in fact, know how to tell if she was lying to me. When I approached her the next day to clear this up, she said, oh my goodness, I found Jesus. I'm so sorry. I was lying the whole time. I'm so sorry. And she basically threw herself on her sword, but it didn't help us because I had this, sense of, I know how to tell when someone's lying to me. It's a very difficult thing to do. I've since then studied the art of deception detection to the degree that I've been out to California and visited with Dr. David Matsumoto, who is one of the leading experts on body language and micro expressions. And he says, if you study deception detection at the academic level for 30 years, you can increase your percentage of telling when someone's lying to you. From the general population, people could tell with a coin toss. It's about 50% you can tell if someone's lying to you. If you study this art for 30 years at the academic level, you can increase your percentage to 53%. So
why study it?
The only way I've found to tell if someone is telling me something that's not true is if it's contrary to fact and I know the facts. And I'm going to assume that when you're dealing with mitigation issues and someone's talking to you about their family history, you have ways to go back and research and find out the factual issues that they've dealt with and tell if they're telling you the truth or not.
You're absolutely right, and that's what I do. So I go in and I talk to the client. I get their entire, life history. I call it a history of person. It's kind of like a biopsychosocial. And then I go and I talk to relevant witnesses or character references, lots of family members, friends, and I make sure that, the story my client is telling me adds up. So yes, I have that backup.
Sorry, we went dark there for half a second. Yeah, that's good. And you can, when someone's talking about their history, birth dates, significant events in their life. You can corroborate some stories with family members and deal with it that way. You can also deal with medical records. I'm assuming that you have access to medical records, and I want to talk a little bit about that. How much access do you have to your defendant's medical history and their medical records?
I pull any and all records, not just medical, but any and all records I can get my hands on. Medical, mental health, school, Social Security, VA records, any military records. And, each client's different. So you have to find out what records will be relevant, what records will help you. And then it's important to know, like if you feel like your client might need a psychological evaluation or a substance abuse evaluation or anything like that, then you need to let the lawyer know to have your client evaluated.
Right. And when you're looking for medical records and stuff like that, do you have them sign any documents allowing you to approach the doctors and the pharmacists and those things?
Absolutely. I have them sign a HIPAA release. And then what I've been doing lately is using an ex parte motion and order to pull the records, and that gets filed with the court through the attorney so that the prosecution doesn't know that we're pulling the records.
Okay, that's good. That's good to know. And when you do that motion, is that something that the lawyer does on your behalf, or do you write that motion for them and then they turn it in? How does that work?
Yeah, typically I'll go ahead and get the motion set up, type it up, and then get it to the lawyer. They take it to the court, have it filed, they bring it back to me, and then I send it out for the records.
Okay. And that brings me to a point for investigators out there. One of the skills that I have found useful over the years, and I'm not as good at it because I don't have a legal background. Lindsay grew up in a family of lawyers, and she has worked in law offices. How long have you been working in law offices, Lindsay?
Wow. I think, I started out at 16 answering phones at my dad's office. I worked for him for about 5 years when I moved back to Lubbock in 2009, a little bit more intensely, but I've worked for several other attorneys as well. I've worked for some civil attorneys. So I got just a little bit of everything.
Right. So, and again, I don't have that strong of a skill set in writing motions. I have been doing it on occasions for some attorneys that I work with. If you're an investigator, I know there's an investigator out of Dallas. I can't think of his name off the top of my head, but he's a former federal probation officer, and he knows how to write motions and orders, and that's a thing that you can do as an investigator to help your attorney out, make their life just a little bit easier. And it's not terribly difficult. A lot of the language is kind of canned language, is kind of the same all the way through. But if you can figure out how to make your attorney's life a little bit easier, that's a value add as an investigator. And I think that's a good point to bring out. Lindsay, let's talk a little bit more about other tasks that you do in the course of a mitigation investigation.
Well, it just depends on first, it depends on what the attorney wants. Second, it depends on what the client tells you as far as what records to get and who to talk to. And then there's something kind of new I've been doing. I work with appointed attorneys through the Lubbock Private Defender's Office. And there's been a need recently for preparing timelines and putting together a packet for drug court purposes, which drug court is a specialty court in Lubbock. It's kind of like a hardcore probation. They have all sorts of things they have to do if they're put on the drug court team. So I'll help with that, putting together that timeline with supporting documents. trying to get these people that, may have several convictions of drug charges and have never really had any treatment, never really had any help, support, getting them on that drug court team. And they have a really good high percentage of completing that program.
Okay, that's good. That's a good little tidbit. And I'm always interested in finding things that I can do that are outside of what normal people would think of as investigations or mitigation, to do that might make a lawyer's life a little bit easier. We got a question from the field, and I don't know the answer to this. I don't think the answer is yes, but the question is, do ex parte records become discoverable?
If we pull them, no. I mean, no.
It's kind of the nature of ex parte. It's done outside of the system so that the DA doesn't know that it's been done.
Exactly. And then we can use them, the attorney can use them in the punishment phase of a trial to, back up whatever we're trying to do with punishment evidence. But
okay. I had a little weird audio feedback there. Did you hear that?
I didn't hear
good. Let's talk a little bit about witnesses. I know as a fact investigator, I know a lot of the people in the webinar today are probably fact investigators or would like to be fact investigators. What's your initial approach with a witness? And kind of what is the order of witnesses that you're looking for in a mitigation investigation? Let's start with the order first. Obviously, you're going to talk to your defendant and their family, but then kind of build a tree from there of who you talk to. And then let's talk after we get that kind of tree defined. How do you approach those people?
Sure. I always want to talk to mom or dad or sister or brother, whoever the client is close with, whoever they say they're close with. Even if they say they're not close with someone, like maybe they had a falling out with brother or something, I still want to talk to brother just to see, what he has to say. Like I said earlier, nothing can hurt the client. It doesn't hurt to get more information than what's needed. But I also want to speak with any sort of character references. So we say like preachers, teachers, coaches, bosses, anybody. Hopefully our clients have someone that can vouch for them. That's not always the case. But friends, neighbors, maybe. It just depends on your client's story as to what witnesses you're going to want to speak with. And sometimes mitigation and investigation go hand in hand, and you end up getting some fact investigation information, and that's okay too. I mean, I'll go with it. I'm just nosy, really.
And
I like to know stuff.
That's what makes you, and that's what makes one a good investigator, is the curiosity factor, the thing that says, I want to know more about this and I want to know more about that. And I know, we have worked on the same case on a number of occasions over the years. And while we approach it sometimes from a different angle, a lot of times some of the information I get ends up being useful to you, and some of the information you get ends up being useful to me. And I think that's one of the things that a lot of private investigators don't think about, is, when we're working with a defense team, it should be a team. And the attorneys, I think the better attorneys that I work with know that everybody performs better if everybody is in the loop on what's going on. So I'm thinking in specific of one attorney that you and I have both worked with. He's really good about saying, hey, Lindsay's talked to this person. Or he's really good at saying, Lindsay, I know Hal talked to these 2 or 3 people, maybe see what he's got that might be helpful to you. So I think thinking about it in terms of a team, and not that I'm in competition with you or you're in competition with me, we're all trying to achieve the same goal, which is get the best result for the attorneys and for the client. Is that right?
Yeah, audio kind of went fuzzy on me for a second, but yes, I agree. Team approach is the best way to do it. You know, typically I work with 2 attorneys and an investigator. Some people are good about sharing their information and some aren't. You never know what you're going to get with the team members, but I agree. The more information that we can all share, the better, and work together. It should not be my information's more important than yours, or anything like that.
And one of the things that we joke about a lot is the idea of we have to check our egos at the door, especially when you're in a lawyer's office and you've got a group of people in the office, and let's be honest, attorneys, investigators, mitigation specialists, we're all pretty opinionated people, and we all like to share what we know. There's a time to do that. There's a time to be quiet, but I like to try and check my ego at the door, because somebody may say something that in a normal situation might hurt my feelings, but I'm not there, and you're not there. We're not in the room to be the main guy. We're there to support, we're there to help. And at the end of the day, our main goal is to get a good result for our client, who is the defendant in most cases. So I think that's an important thing to remember.
I absolutely 100% agree.
Okay, I've got another question come in. How often do you use investigators to help with your mitigation? Are there any subjects or areas of life that you're not allowed to talk about in mitigation? That comes from Brian.
I am me, myself, and I don't have anybody that I work with or that works for me. So no, I don't. And I work with them. And then what was the second part of the question? Oh, are they not allowed to be discussed?
Yeah, are there any areas that you're not allowed to talk about in mitigation?
Hello?
Any things that you're not allowed to get into?
I'm sorry, we're kind of cutting out, but no, I talk about everything. I mean, I don't ever give legal advice, but I try to cover. I want to know it all.
Yeah, and I'm kind of the same way. I don't think there's anything that I'm going to learn in the process of an investigation that is going to be damaging to my client. I want to know everything I can, and I think from a fact investigation standpoint, anything I find out, the lawyers need to know about it. If it's a bad fact, at least they know it and they can deal with it.
Absolutely.
Yeah, I mean, you got to know what's coming down the pike, and you got to assume that the other side knows, probably knows the bad facts better than we do. So anything we can do to find out as much information as possible, I think is helpful. We got another question from the field. Someone asks, do you talk to kids? Do you ever talk to children in the process of an investigation like this, a mitigation specialist?
Sure, I have before. Always get the go-ahead from the parents to speak with them. But, not often, but I have.
Okay. And if you're dealing with children, are there any special things that you need to consider, or do you just get permission from the mom and dad and then go with it?
Well, depending on how comfortable they are, I might have mom or dad sit in the room with us. That's okay, just to, cover my butt. But special, no, I mean, you talk to them differently.
Right.
I'm probably a little more sensitive with a kid, especially. I remember I had one case, and the child wasn't, real young. He was 15 or 16. But the case involved his dad, and his dad had committed a crime, and but I wanted to talk to the son about his dad and how he felt about him, and he was, he was standoffish. It was a weird situation for him, and you got to understand that. I mean, put yourself in his shoes. Of course, that's going to be hard, but so you want to be, pretty sensitive to that.
Let me ask you this: when you're dealing with witnesses, if you're trying to set up an interview, if you're approaching witnesses, what is your standard method for approaching a witness? Do you knock on the door unannounced? Do you make a phone call first? Do you get an introduction? How do you go about approaching witnesses?
I hate knocking on doors. I know you love it.
Let's be clear. I don't love it. It's terrifying.
No, so if I can, I call, I make an appointment. I don't like to, but it's sometimes necessary for me to go to their house. Not always comfortable with that, but I always have to think to myself, I'm on their side. I'm not the bad guy. I'm there to help them. So that kind of gives me a sense of peace about what I'm doing. And typically when I go in, everything's fine. I've never had any troubles. The one time, or no, it's probably not the one time, but it's the most memorable time to me that I knocked on someone's door. She was pissed that I came to her house, and I had to inform her, and I really had to talk her off the ledge, but that I was there because I didn't have a good phone number for her. All I had was an address, and it was Mama Bear. And that I was there to help her son, not for anything else. I was not the police. And she finally came down, and she ended up giving me a hug at the end of it. So
That's a good result. You and I have talked about this on a number of occasions. I don't love knocking on doors. I do it on a regular basis. In the past 10 years, I've had 3 guns pulled on me by now. I've been dog bit, dog cussed. I've had 2 handguns pulled on me, 1 shotgun, and the shotgun really got my attention. And I had an ice pick pulled out on me at one time. So walking up to the door it can be a dangerous thing. And for the investigators out there, the fact investigators out there watching, you have to be very careful with approaching witnesses unannounced without an introduction. It can be dangerous.
do you carry?
Say again?
Do you carry?
I do not. I have a conceal and carry permit. I realized about 5 years ago that I'm just not going to shoot anybody. I can run in a serpentine fashion. I can put my hands up and walk backwards to my car. I've never felt in fear for my life. I have been terrified by a shotgun once. And in that case, it was a Texas case I was working on. And for folks that are from Texas, you're going to appreciate this. This was a double wide trailer out at the end of a mesquite run. And I knocked on the door, and this beautiful little girl came to the door, blonde hair. And I said, "Is Miss So-and-so here?" And she said, "I don't know that name. Let me ask my mom." She went inside. Then about 30 seconds later, the door flings open, and this guy racks one into the chamber of his pump action Remington 20 gauge shotgun. I know exactly what gun it was, points it in my face, and we're maybe 3 feet apart. He's got one crazy eye that's looking off in that direction, and the other, and it's kind of cloudy, like he got punched in the eye way back in the day. And the other one is like crystal blue, staring at me, and he says, "Get the off my property." I was like, "Not a problem, not a problem." Walk back to the car. So, yeah, it can be kind of challenging at times. I'm going to take a second here real quick. And since we have talked a little bit about deception detection and the difficulties of telling when someone's telling you a lie, when the email goes out tomorrow to the people in the webinar, we're going to include a discount code for a course on PI education called Grasping at Heels, Deception Detection 101. We're going to be offering a 15% discount. We'll send that discount code in the email to the people that are actually joining us today. So we're pretty excited about that. And again, this is the monthly webinar hosted by PI Education. And this is October's webinar. We're thrilled that you're here. We still got about 50 people in the room. And I hope you're getting some good information out of this. Lindsay, let's go back and talk a little bit more about mitigation. How much time do you normally spend with your defendant when you're doing the initial interview and throughout the course of your mitigation investigation until you get to trial?
So my initial interviews typically last anywhere from 3 hours to, I think I had one that took about 12 hours. But that was not all at one time. I had to, come back several times. And then it really depends on the information I gather after speaking with my client for the first time. If I have questions or if I need more information, then I'll, that will tell me how much I need to go and see my client. Also, if I'm ever at court dates with the attorney, I'll, speak with my client there, like at a pretrial or something. But yeah, it depends on the information that I gather that will tell me how much more time, I need to spend with my client.
Right. That makes sense. So when you're approaching your client for the first time, do you block out a 3-hour time window, or do you block out a 4 or 5 hour time window before you go? Or how do you plan your day when you don't know how long the interview is going to go? Do you just block out a certain amount of time and allow that much time?
Yeah, lots of my clients are in jail. And so I have to call and make an appointment to meet with them. And so I'll usually meet with them in what's called the pretrial room, which is an open air room. They have to shackle them, unfortunately. But at least I don't have to meet with them behind a glass, a glass mirror or window. Sorry. And so, yeah, when I make an appointment at the jail, I have to say I need from 1 to 4. And then if I need more time, I'll make another appointment, but it might be days later because there's only one pretrial room at the jail in Lubbock. And so people book it up. But if I'm meeting with my client, that if a client's not in jail, then I just meet with them for however long we need to meet. And if I feel like if I feel like our conversation isn't going anywhere, or if we need to come back to it. Sometimes my clients get pretty emotional. Mm-hmm. If I feel like we need to stop and come back to it later, I can do that too.
Have you ever found yourself in an interview that the client has gotten, the defendant has gotten emotional and it feels awkward, but you just stick with it because there's something good coming down the pike?
Sure. I mean, I have very rarely do I have clients that don't cry. And when they don't cry, that kind of makes me nervous because we talk about emotional things. We're talking about their life. And typically there's some pretty sad things that have happened in their lives. I think there's really only been a few occasions where I've actually had to stop the meeting because they've shut down.
Right. Real quick, we got a question from Julie. She says, have you ever worked with the hearing impaired, and how do you deal with that?
No, not in a on a legal case. I have a cousin that's hearing impaired, but no, not legally.
Okay. And I have not either. I would assume, Julie, if we were working on a case where someone was hearing impaired, they would provide a signer to work with us or something like that, or possibly a talk to text app that would allow us to communicate with them. When we're dealing with disabilities of any kind in a legal situation, I think we would have a lot of resources that we could use to help us out in this situation. I mean, the court of all institutions, the court is going to understand the Americans with Disabilities Act and the need to accommodate someone's disabilities. So that's a good question, Julie. I've not dealt with it, and Lindsay hasn't either in a professional sense. One more question for you, Lindsay. What are your favorite internet research tools and resources? This comes from Stephanie.
Sure. I Google, I Facebook. You can find loads of information on someone's Facebook account. I also use, in a little sense, I use Westlaw Next, the people search. It will give you addresses, old addresses, phone numbers, if they have any criminal history, any civil case information, how they vote in an election, if they have any foreclosures on their houses, plethora of information. Also in Lubbock County, I use the Lubbock County system to, look up if they have any civil or criminal history.
Right. And talking about things you can find through Westlaw and Accurate and those kind of services, I know from a fact investigator standpoint, I have been able to use those services to get, for instance, if someone goes through a divorce and it goes to trial and the divorce record is part of the public record, that can be a wealth of information for a fact investigator. It can provide avenues to approach a new witness, someone that might not have talked to you before. But I'm assuming from a mitigation standpoint, you could find some really interesting information in those kind of records. Do you get those records and go through them and read as much as you can?
It depends. Usually if I'm using Westlaw, I'm trying to find someone, trying to track someone down. But yes, I've used that to find information on people. I use it a lot if I'm working, if I have if the attorney wants me to help with jury selection. Find out the jury panel, but that's another subject.
That's a whole nother subject, and it's a fun subject. And I think based on the response that we're getting today, I think there's probably going to be a demand for you to come join us on another one of these webinars. So we can talk about the jury selection process. I know that you and I have both worked on mock trials and focus groups in the past, and I find those to be intriguing at the very least and amazing at the best, the information you can get out of a mock trial. But that's not the topic for today. We're talking about mitigation here on the PI Education webinar for October. I'm joined by Lindsay Craig from Lubbock, Texas. She is a mitigation specialist. Lindsay, I want to go back to the time you spend with witnesses, and let's talk now about family members. If you're talking to mom, dad, or even a sister or a brother or someone like that, how much time will you typically spend with those people, family members?
Oh, well, for an initial interview, maybe an hour. And then we go from there. Could be a couple hours. I know I've spent I have a capital case that I'm working on right now. And I've spent a lot of hours with mom, a whole lot.
Right. And
I don't even know how many.
That's the way it goes in this work. Sometimes you get in and you don't even keep track of your hours. Sometimes I just forget to keep track of the hours. And furthermore, if you're working court appointed cases, sometimes you just have to give away some of your time. It's just the way it goes.
I don't like to waste their time with appointed cases. They don't like you to waste their time.
Right. And I got to say again.
Information you can get in the least amount of time.
Yeah. And that's a key thing is like, it's you've got to work with some model of, efficiency and diminishing returns, at some point, if the conversation just goes on and on and on and on, and you end up hearing about their dog and their kids and stuff that's not pertinent to the case, you can waste hours and hours just letting someone talk and get nothing. I think that's a really good point to bring out. So when you're talking to family members, you're talking to your defendant, you're blocking out a lot of time to talk to these people and get a lot of information. And I know on capital cases, do you spend more time talking to the family, getting criminal or getting mental health and physical health backgrounds on capital cases than you do other cases?
Absolutely.
Okay. And that's just simply because the stakes are higher?
Sure. Yeah, I mean, I put forth a lot of effort on my felony cases, but the capital case that I'm working on has definitely taken up more time than most, but I still use the same procedures.
Right. And that's one of the things when we talked about doing this webinar together, I know that a lot of people want to talk about nothing but capital cases. And I'm right there in the group of people that think that those are terribly important. But there's also the more, for lack of a better word, pedestrian cases, your felony cases that pretty much anyone could find themselves in if they don't pay attention to what's going on. Those, I think, deserve a fair shake. And I think mitigation is oftentimes overlooked in simple felony cases when it could be a big help. Talk to me a little bit about your felony cases and how is there an example of a case that's not a capital case where you did mitigation work up front and you ended up with a really good result?
Absolutely. And I'm just going to say that as of right now, I'm the only mitigation specialist in Lubbock, and I have a lot of work, which tells me that there is a need. There is a need for mitigation, and lawyers are seeing results from mitigation investigation. So yeah, let's see. Gosh, I have a lot of cases. I have two cases that were, both of my clients had been in jail. One had been in jail for about a year. The other one had been in jail for about 3 years. And after I got involved with the case and started working on the cases, I spoke with several witnesses that talked about how my clients, well, we'll just talk about one of the cases. He was charged with, I think it was continuous sexual assault of a child or something like that. It kind of borders on investigation, but it was for mitigation purposes. And all the witnesses I spoke with were saying, he did not do this and this is why. And they kind of gave me some insight into who he is and why he wouldn't have done what he was charged with, and why the people that were accusing him had reason to say he did this. And the attorney ended up taking it to the prosecutor, and they did the case, and he got out of jail. So, I mean, I know he's happy, but man, he has no recourse. I was falsely accused and sat in jail for years, and then they just decide to dismiss the case. And I think that happens a lot. I think prosecutors are pretty overwhelmed here in Lubbock County with cases, and they don't closely enough until we start providing them with information.
Yeah,
I think that's where that's an issue.
Yeah, I think it's definitely an issue. And that leads perfectly into the next question we have. I can't see who this is from, but it says, do you often deal with cases where you believe the defendant is falsely accused, and do you handle those mitigations differently?
Well, there's different things you can do, but yeah, I definitely I'm not all my clients are innocent, but definitely there are some that I believe, and at that point, you need to know where you need to go, and look into having a polygraph done. That's helped on a few mitigation, but explaining to your attorney that you think that could be a possible route to go. I think I handle it differently. I still pull records and witnesses. I do it differently. Have we paused?
I think I lost you there for a second, but it's just a technical issue. I think what you're saying is you don't necessarily handle these cases differently. You approach them all with the same kind of gusto and due diligence process. And
Right.
I think that the answer that I would have to the same question from a fact investigation standpoint is, yeah, when you have someone that you know is innocent, that you believe strongly is innocent, you want to get everything done, but you want to do that on every case.
Right.
And that's just kind of the way this work goes. Everyone is constitutionally entitled to a full-throated defense, and we are part of that team. We're part of that process. John asks us, do you enjoy what you do? And this gets into the last topic that you and I talked about that we're going to try and get into is, he says, what would you advise someone who wants to enter this profession to do, education-wise, self-awareness, working knowledge, et cetera? How would you advise someone that would like to look at, and especially since we're dealing with mostly private investigators out here, what would you advise them to do to get into the mitigation specialty?
Well, as you know, right now in Texas, you don't have to have a license to be a mitigation specialist, but I think a good background to have would be communication skills. That's key. You have to know how to communicate with people, how to build rapport with people, gain their trust, how to take reports, how to maybe transcribe things. You have to, I think having a little bit of legal know-how would be important too. A little bit of knowledge of how the legal system works, how to work as a team. As far as education, I can't say that one degree would be better over another, but I think communication is just important. So whatever, you do, learn how to communicate with people, belly up to the bar, meet someone new, find out who they are, talk to people. I think law school would be great for a mitigator to have that background. I think to have an investigation background would be good. Counseling's good.
I think you're in a unique position, Lindsay, and I've met and worked with several mitigation specialists across the country, and I think you're in a unique situation with your counseling degree and your background in counseling and your knowledge of mental health from that perspective. I think that would be a good thing for someone to look at, is the possibility of getting some education in counseling and mental health. That wouldn't be a bad thing. You're absolutely right. I tell everybody the one real regret I have over the years is my dad offered to pay for me to go to law school way back in the day, and I just never wanted to do it. Now I kind of wish I had, because I think one of the main benefits of going through law school is not necessarily a knowledge of the law, but a different way to think about things. Most of the really good lawyers I know, they just think about things in a different way. And I think that would be very helpful for mitigation specialists.
Well, you're never too old.
I feel too old. Um,
Me too.
there's an investigator that works out of Boston, John Nardesian, I believe. He has a law degree, and he makes for an amazing investigator because he has that knowledge. So, John, I would say, anything you can do, and I like the question being asked about self-awareness. Some people just aren't made for mitigation work. It is deep, personal, intimate work. You're going to spend a lot of time with people, and you're going to hear sad stories over and over. And I worked on a case years ago where the young lady had been convicted of capital murder, and she had kind of gone almost all the way through her appeals, working on kind of last ditch effort for appeals. And we discovered that she had been physically and sexually abused from the age of 2, by her dad and by her uncle and by their friends and by pretty much anyone who happened to come by the house to smoke pot with the family. And it's a horribly sad story. And the ability to sit and listen to those stories and have some degree of empathy and some degree of understanding is it's a thing that can be learned. But I think a lot of us that do the work are just that kind of people. We're empathetic people. We like to hear other people's stories, be they great stories or bad stories. We just like to hear the stories. And part of the pitch for this webinar was mitigation specialists help attorneys tell better stories because the attorney has a fuller picture of their client. They have a more well-rounded picture of their client, where they came from, what kind of abuses they suffered, what kind of things they did. We're getting really close to running out of time here. I want to touch really quickly, Lindsay, if you don't mind, on the difference between positive mitigation and negative mitigation, and how those might be used at trial.
Sure. So positive mitigation to me would be, someone owns their own business. They have a great family. They are, a really good dad or a good employer, good boss. And then the negative mitigation would be they have maybe a history of poverty. They came from a poor family, maybe lived on the streets. Started using drugs at an early age. Maybe their dad taught them to smoke pot. Started dealing drugs. That was the only way they knew how to make money. Stuff like that. But everybody's story is different. And sometimes you get the negative mitigation with the positive mitigation, and you interweave it. It depends on their story, and you have to tell their story. And I think it's very important for lawyers to get to know their clients. And if that's by using a mitigation specialist to help them, then so be it. However they have to do it.
Yeah, absolutely. And I think for the attorneys sitting in with us today, again, I've known Lindsay for quite some time. I find her to be a consummate professional. The mitigation specialists I've worked with over the years have been some of the most amazing, intuitive, thoughtful people I've ever had the pleasure to work with. The ability to sit and spend time with the client and get information is crazy strong with these people. So if you've never thought about hiring a mitigation specialist, give it some consideration. If you're working an appointed case, a lot of times the court will appoint a mitigation specialist and cover the cost. So at that point, it's basically free legal help. It doesn't hurt to have someone else on the team. We're getting right down to the wire. Got about 15 seconds left. Lindsay, thank you so much for joining us today. I totally appreciate you doing it. And we'll get you back for another one, I promise.
You're welcome. Thank you so much for having me. That was fun.
Great. And just the last thing we're going to do today, Grasping at Heels, Deception Detection 101 is the course we're going to be sending out a discount code for tomorrow. We're going to offer a 15% discount on that course because Lindsay and I talked about the process of trying to tell whether or not your client is telling a lie. It's a difficult thing to do. I'm Hal Humphreys. This is PI Education's monthly webinar for October. Thank you so much for joining us. We will catch you next month. And I think next month we're going to do the third Thursday of the month, since the fourth Thursday is Thanksgiving. So thank you for joining us. Have a great weekend. We'll talk to you later.